Good morning and welcome to the 27th meeting of the Education and Skills Committee in 2019. Can I remind everyone present to turn their mobile phones and other devices to silent for the duration of the meeting. Apologies today have been received from Jenny Gilruth, and Gil Patterson is substituting for Jenny this morning. A warm welcome to Gil Patterson. Agenda item 1 is decision on taking business in private and its decision whether to take consideration of the draft report on STEM in early years education in private at future meetings. Is the committee content to take those considerations in private? Thank you very much. Agenda item 2 is our second evidence session on the Disclosure Scotland Bill. We heard in September from the Bill team, and today we will hear from a range of organisations with an interest in the bill. And I'd like to welcome to committee this morning Nicola Dickey, Chief Officer of Children and Young People at COSLA, Alison Reeds, Principal Solicitor from Clan Child Law, Sheena Brennan, Information Manager from Disclosure Police Scotland, Andrew Alexander, Head of Policy from the Law Society of Scotland, and Cheryl Campbell, Acting Director of Regulation for the Scottish Social Services Council. And can I ask each of you just give a very brief introduction of your interest in this area, and if I could start with Ms Dickey.
Thank you and good morning, and thanks for the opportunity to be here. So from a COSLA perspective, we are supportive of the broad approach in the bill, and it seems to strike the right balance for us between public safety and supporting individuals' rehabilitation. We recognise that the current system is complex and often confusing, and we support the bill's aims to streamline the disclosures and close those loopholes. We recognise as well that the financial impact on local government is estimated to be minimal, but this is set against a climate of significant reductions to core local government funding, so all new resource implications must be fully met by the Scottish Government. So I think from our perspective we are broadly happy, and that view from a COSLA perspective is shared by our elected members, with colleagues in Social Work Scotland, and also from our heads of personnel networks. So from our perspective we're broadly happy.
Thank you very much. Could I move to Ms Reid?
Hello, my name's Alison Reeds. I'm the Principal Solicitor at Clan Child Law. Clan Child Law is a unique legal outreach service solely for children and young people in Scotland. It enables young people to have their voices heard and to participate in decision-making processes which affect them. We're specialist lawyers for children and young people. Clan enables young people to know about their rights to access free child-centred outreach legal help, allowing them to get the supports and to be treated in a way which they are entitled. The vast majority of young people we represent are care experienced. We take issues that arise in our direct casework with young people and try to make the law better for all young people and children for children and young people in Scotland. Our concern around the effect of childhood offending type behaviours later in life has long been one of our priority policy areas from which we have experience in practice. This led us to intervene in the Supreme Court last year in the matter of an application by Lorraine Gallagher and others to assist the court with the details of the Scottish system. Every day we are representing children in children's hearings, and the issue of disclosure frequently arises as young people are being asked to accept offence-based grounds without knowing the consequences for them when they are applying for a job or college course when they reach the age of 16. We're also often asked by young people when they're applying for their first job if anything will appear on their disclosure. Given our involvement with the scheme, we have restricted our response to consideration of childhood behaviours only. Thank you for the opportunity to come here to give evidence today, and I hope I can be of some assistance.
Thank you. Ms Brennan?
Good morning, Convener and committee members. Again, Police Scotland welcome the opportunity to attend this morning. As you know, this is the first review of the primary legislation since its enactment. Police Scotland is very supportive of its revised terms. We have worked closely with Disclosure Scotland since the introduction of Part 5 and PPG legislation, and we continue to work together with them on this bill and related legislation. We obviously have the current process and a number of major changes in relation to the bill, which we very much welcome, ranging from the membership moving from lifetime to 5 years renewable, and that will reduce the number of scheme members and the duty to ourselves of ongoing monitoring. The current membership changing to role or post specific replaced by regulated roles, again, very much welcomed. The fact that the scheme will become mandatory for identifying post or job holders, addressing what we see as a shortfall in the existing legislation. And the existing dispute process will be replaced by representations to be overseen by the role of the independent reviewer. This obviously mirrors a situation down south where they have the independent monitor. And again, our role with the responsibility of disputes to ORI going to the information reviewer independent reviewer, is welcomed and will be assessed as the bill moves on. And we also welcome the very fact that we will then produce statutory guidance to the Chief Constable for the quality assurance framework. Again, Police Scotland follow the Home Office guidelines at the moment, and we would welcome the Scottish guidance for a quality assurance framework, which the Disclosure Bill will introduce. But overall, we're very supportive of the Disclosure Bill and welcome the opportunity to discuss it further today.
Thank you. Mr Alexander.
Thank you very much, Convener, and thank you, committee members, for the opportunity to attend today and to assist the committee in its scrutiny of this bill. At the Law Society, I think that we are broadly supportive of the bill, sort of in the way in which it balances the protections to the public and also the importance of rehabilitation. We think that the simplification of the bill is a welcome step to take. And we appreciate the fact that we, as a regulator and as a user of the disclosure system, have had the opportunity to engage with the Scottish Government and with Disclosure Scotland around the way in which the bill may impact us as an organisation. We do think that guidance will be important to allow us to be able to discharge our public functions, particularly around the way in which tests of relevance and ought to disclose will operate, sort of we think that that will allow us to have the clarity to be able to progress, sort of with the new disclosure system, to allow us to ensure that we are maintaining the professional principles of a regulated legal profession. Thank you.
Thank you. And Ms Campbell.
Okay. Good morning, and thank you, Convener and committee members. I'm Cheryl Campbell. I'm the Acting Director of the Scottish Social Services Council. The SSSC welcomes the opportunity to be before the committee and to provide evidence in relation to the Disclosure Scotland Bill. As an organisation, we regulate the Scottish social services workforce and protect the public by carefully assessing applications for entry to our register. We also take action against those applicants and registrants whose behaviour falls short of the standard expected. Disclosure of information plays a key part of our assessment. We consider the bill represents a welcome simplification to the current system of disclosure, and mandatory element of PVG is welcomed also. We look forward to working and continuing to work with Scottish Government and Disclosure Scotland in advancing its aims, and hope to be able to assist the committee today.
Thank you very much. If you do wish to respond to any of the questions, please indicate to myself or to the clerks, and we'll ensure that you get in. We have quite a broad range of topics to cover this morning, so I'll move on and invite Dr. Allen to come in.
Thanks very much. I was interested in what the bill has to say, or perhaps doesn't have to say, about under-16s and where they fit into this picture. Obviously, I think we want to avoid twin risks of someone who is a danger and who's under 16 slipping through the net, or getting into a situation where there was restriction of the voluntary work that younger people might do. But I'd be keen to have your views on how you feel it works, the fact that under 16s will not be able to join the PVG scheme.
Perspective, the numbers of people who are currently under 16 in the PVG scheme is fairly limited. From a COSLA perspective, and in broader discussions with the professionals that support our young people, getting it right for every child in effect means that many of those young people, if they are troublesome or there are issues around about their behaviour, will already be well known to those support services, be it social work, teaching staff and or Police Scotland, depending on the level of of the difficulty of their behaviour, many of those young people will also be involved in the children's hearing system. So I think in terms of the proportionate risk of having them out with the system, balancing that against having them in the system and continually monitoring their behaviour for a significant period of time, I think we're pretty comfortable that the bill strikes the right balance from a local government perspective.
And I know this is a point that my colleague Ross has raised in previous meetings on this subject, but how would voluntary organisations know that such a person was in the scheme if they were approached by that person?
So I think, again, in the policy memorandum, the Scottish Government are clear that that would be it would be in effect for a kind of between Police Scotland and the lead professionals to be having that conversation with the young person themselves and expecting that young person to disclose that information themselves. If that was not the case, they may well have to disclose information, but I'm almost sure Police Scotland will have a thought process on that.
I would agree with Mr. Key. We've got a situation where I think if you had behaviour of concern and were under 16, you would be known to a number of professionals who would be ensuring that they would not then be working within that area of volunteering, and I think it would be, in most cases, it would be volunteering. You could look at it and think that there was a potential gap. I think organisations have their own safeguarding responsibilities as well to ensure that if you did have an under 16 working within that in your organisation, you would be placing other restrictions, to ensure that, well, you've not got a PVG certificate, you then would have restrictions to ensure that you're not working one-to-one with, vulnerable children or whatever. I think there is a partnership working scenario here. It may be that that is something which, if you look at the Scouts are an organisation which is across the whole of the UK, and again their safeguarding responsibilities is something they would address there. But I think it's a very unusual situation. I think maybe if you had an individual who was under 16 who had behaved in such a manner, it might be an auto-barred offence, so it would be automatically something that Disclosure Scotland would find themselves disclosing as a duty of care.
And I suppose maybe related to some of these issues as well is the concept of spent convictions, thinking about people throughout the whole of their life potentially. And keen to know any views you had about how the proposals to change the system deals with that concept of spent convictions, whether you feel it changes, whether you have any views on the way that the new rules would deal with the concept of spent convictions and people's potential for rehabilitation, monitoring people.
I would say that the management of offenders legislation associated with the age of criminal responsibility, the fact that the 12 to 17s, is in a different situation with this Act as well. Disclosure Scotland obviously have implemented the Schedule 8A and 8B lists for the filtering of the information, and again that's all to benefit the individuals who have that right to rehabilitation, and if it was a more serious offence then obviously it would not be caught within the rehabilitation guidelines.
So we have some concerns around the proposals for the way that childhood convictions are being treated in the proposed bill. Firstly, we're worried particularly around children's hearings. Given that the children's hearings is a welfare-based system and it's looking at what is in the best interests of the child, we feel that there's a dissonance between the negative outcome of the disclosure scheme and the welfare which is trying to be achieved through the children's hearing system. And we see that as problematic and potentially challengeable under Article 8 of ECHR. The big concern for us around that is, and we really, the purpose of the children's hearing in this context is to divert a young person from their offending behaviour. And we really question if enduring adverse consequences on children as they move to adulthood is an effective and proportionate way of achieving this. And for us, this raises concerns around Article 8. We're also concerned for the group as a whole, for under 18s who are being in the adult court. Given that the Scottish Government is committed to the incorporation of the United Nations Convention on the Rights of the Child and to making sure that children are looked at in a different context to adults, our view is that all under 18 should not be accruing convictions. If there is something serious, our view is that it could appear as other relevant information, and I can talk more about that. I think there's a high bar required for other relevant information in relation to children as well.
Okay. Perhaps finally a question for the Law Society, and it may relate to the points that have just been made, or it may not. It was more generally about what you feel is the robustness of the new system being proposed, given that there have been legal challenges to the previous or the existing system and similar systems in England throughout the UK. So just any view you have about the robustness of it in the face of those challenges that it might face from individuals?
I think that, sort of obviously, sort of Alison has highlighted, sort of areas where there is the potential for challenge, and it is always feasible that, sort of individuals may look to test, sort of on Article 8 grounds, the ways in which, sort of the disclosure system operates. Also, there could potentially be the prospect of challenge under potentially Protocol 1 to Article 1, sort of human rights challenges around interference with property, because a disclosure can, sort of have a direct impact on someone's livelihood. But as the system stands at the moment, sort of approaching the bill, I think that the system is reasonably robust. There is a degree of flexibility, and so I think that we are not particularly concerned around that. Some of the detail would be helpful to flesh out, because obviously if we're in a situation in which the process in actuality isn't one that's fair to sort of the individuals involved, I think sort of there could be particular difficulties there. So one of the areas that we'd highlighted was around the kind of prescribed periods during which reviews could take place, because there is, I think, a degree of tension there, because often if a disclosure is for the purposes of employment, then the review process might need to be fairly quick. But equally, if a review process is particularly short, that might not actually allow people to get the opportunity to be able to adequately represent their position, or indeed to be able to get independent advice on what could be some serious consequences. But we think that the bill, sort of, is, sort of, I think, a reasonable, sort of approach in light of current decisions. It's always difficult, I think, to future-proof legislation regarding potential future challenges.
Yes, Ms. Reid? Yeah.
Just when I was looking at the compatibility question, I had three other areas that I was concerned about, apart from the one that I've raised already around children's hearings. The second one was around the ought to and relevance test, because the law has to be foreseeable. And at the moment, without the detail of what that is, it's really hard to be able to advise young people or any person as to what actually will be disclosed. So I think that more detail around that those tests is required. The third point was around the other relevant information, which I'm sure will come on to around it's got to be proportionate, and given that this information is not proved information, we think that a very high bar will need to be set around the other relevant information, and a really close link between the disclosure and the risk that is trying to be protected against in order for it to become compatible. And fourthly, is around the complexity of the scheme. The law has to be foreseeable, and I understand that it has been simplified to some degree, but it still remains pretty complex.
Okay,
Thank you.
Ms. Ross, did you want to come in?
Yeah. I just wanted to follow up on the human rights aspect, and I invite everybody to answer, but I think, Alison, it's probably the evidence that you gave, and you also mentioned it just now, and I'd just like to go into that in a little bit more detail. You say about, in your evidence, a system so complex, as you said just now, there's a lack of foreseeability, and it is at risk of being incompatible with Article 8, and that's the respect for a private and family life. Can you maybe expand on that a little bit more as to the challenges that have been and how this is different, or how you see it being different?
Yes. I suppose the law has to be understood and it's got to be foreseeable. And I suppose where I'm coming from, that we're trying to explain the scheme to young people who've got potentially complex mental health issues, they've experienced physical and emotional abuse, trauma, exposed to neglect. And what we're trying to do then is explain really complex concepts. And it's not that each concept in itself it is difficult, it's once you get them all together. I also deliver training on this subject to professionals working with young people, and it's difficult. You've got to understand the concepts of what a conviction is, what it is to be, is it spent or is it unspent, the other relevant information, the lists, and whether the offence fits onto the list or not, whether it was heard in the children's hearing system, was it brought as offence grounds rather than care and protection grounds, was there a time lapse that's gone since the incident, and then whether it's level 1 or level 2 as it now is. So by the time you've got all those concepts in, it becomes quite tricky to explain. And I understand that it does to some extent need to be complicated because it's not straightforward. So I mean, I'm not trying to overstate that.
Is there any way at all that you could see it being made simpler in the way that you described, even from what we have now?
So in relation to childhood, the way that childhood offending behaviour is being addressed, our view is that it shouldn't be treated as a conviction, and that would simplify the system, substantially, because then any childhood behaviours would then be treated as other relevant information. And that would then take out the whole column in the table that I tried to create in the evidence to try to explain the system, so that it would just leave us with other relevant information. And of course, and I think, as I said before, a high bar needs to be set around what other relevant information is, and some certainty around what that is, and a link between disclosure and the risk that is trying to be protected against. But that would certainly simplify it for the purposes of children.
And would that fit in with the second section of Article 8 about the public safety aspect?
In my view, it would, in that if there was some circumstances that still required to be told to a prospective regulator or employer, then that could be done under the other relevant information, with the high bar being set, given that it's childhood.
Okay, thank you.
Thank you. Mr Johnson?
Thank you. In some ways, I'd quite like to follow on from that line of questioning. One of the clear policy intents of this bill is to simplify the disclosure regime, and indeed it does so by reducing the number, the categories of disclosure from 4 to 2. But I wonder whether or not, in creating one single level of enhanced disclosure, there's indeed a lack of, to use Alison Reeds' terminology, foreseeability as to what might be disclosed within that, in terms of there's now a very broad range of different types of information that might be disclosed within a level 2, whereas previously, with the 3 levels of enhanced, you would have a degree of predictability about what might come. And I was just wondering if the panel would agree that there's potentially an issue there, perhaps a little bit more wide than just for people with childhood convictions, as Alison Reed was outlining.
I think from from a COSLA perspective, we recognise that this stuff is complex by the very nature of the fact that you're trying to shoehorn everybody into the same kind of disclosure scheme. I suppose whatever the bill we end up with looks like, one of the things that I think will be desperately important will be a public publicity campaign for both members who are joining the scheme, but also for prospective employers. And I suppose an awful lot of that's around about, you know, that will help children who or people who have disclosure that they're going to have to come forward. But I think you're absolutely right. In changing from 4 levels to 2 levels, it is a simplification, but it will not come without its own consequences. And part of that, there has to be some sort of undertaking in the financial memorandum to actually raise the profile of what we've done and why we've done it. And that's important so that it is foreseeable as much as it can be for people who are in the scheme, but also for public perception as well. So I think we have to be really careful around about what it is we're trying to establish and why we want to do it. We need to be absolutely clear on that. And that's in amongst the same public conversations we're having around about the age of criminal responsibility and the UNCRC. So I think we just have to be aware that public awareness of these things is growing, but we need to make sure that that's an important part of what we do as we move forward.
Sorry, I think Ms Campbell wanted to come in.
To say that the Scottish Social Services Council is part of the stakeholder advisory group reviewing Disclosure Scotland, and it is a very complex area of work. It's a very diverse landscape, and it's a real challenge to get the balance of rehabilitation against protecting the public. And through those stakeholder advisory meetings, it's been very clear that people have been on different sides of the fence and trying to come together to some sort of compromise. And I think what the bill presents is that compromise, although it is still rather complex. I think it goes some way to simplify things, but trying to meet those both elements.
Is there not a problem in that? I mean, I totally take Nicola Dickey's point about the need for publicity, and I think that stands to reason. The problem we have right now is we couldn't design that publicity campaign because we actually don't know what criteria would apply, because that will be entirely down to guidance. So, I mean, both Clan Child Law and the Law Society point out that the only tests we have that are on the face of the bill are relevance and whether or not it ought to be disclosed. And until we actually have that guidance, it's actually very, Cheryl Campbell said that there's a compromise. At the moment, we actually don't know what the compromise is because we don't have the criteria in front of us. Is that a correct way to summarise where we are?
Yeah, I would say so. And one of the things that we would welcome is an opportunity to work collaboratively with Disclosure Scotland on the development of that guidance, so that all of our considerations are taken into consideration, and not just the Scottish Social Services Council, but other bodies.
Can I put a direct question to both the Law Society and Clan Child Law? Should some high-level principles be put on the face of the bill, both in terms of providing clarity, but also would that actually also provide a degree of the ability of legal redress? Is there a weakness in relying on guidance and just in terms of the legal certainty that people might have?
So if we had highlighted in our response that the tests of relevant and ought to were ones which we had concerns about without guidance being in place, because there is a degree of certainty that's required for people who are applying for disclosure, and also for the people in receipt of that, to make sure that we've got that balance correct. And I think that it is difficult, so there may need to be a degree of flexibility. We don't know whether kind of the jurisprudence around how that balance is dealt with will kind of shift over time, not just here in Scotland, but also kind of across the rest of the UK, which we'd want to remain consistent with. And I think kind of either kind of guidance that was available for scrutiny, sort of at this stage would be helpful, or alternatively, there is the prospect of, sort of including high-level principles within the bill, potentially with the ability to use regulations to be able to amend those, either through a negative or affirmative process, should those principles find themselves out of touch with any emerging jurisprudence at a later stage. But I think that it is an area where I think that being able to see how these tests of relevance and ought to disclose, sort of may operate will, I think, kind of be, sort of a large part of it. For instance, as a regulator, we might be interested in and think that it would be relevant to have disclosed, for instance, an offence under the Solicitors Scotland Act. And depending on the approach that was taken around relevance, would that be a nuanced enough approach to say, well, as this is for the purposes of deciding on admission as a solicitor, then that would be relevant and ought to be disclosed? Or would a more general set of principles around how this might operate in terms of positions of trust and the like take place? So I think we do think that there is sort of undoubtedly kind of scope to provide greater clarity around these two particular tests.
Yes, I agree. Our view is that we're looking to be able to advise young people as to what this will mean, what will happen, what's the consequence, and we need to make that foreseeable. And so my preference would be to have it really clear on the face of the bill. It just means that is preserved and it is more easily challengeable if there's something goes wrong. I'm hoping that it doesn't, and that's the last thing we want. But it just makes it clear what the scheme actually is, and what the tests actually are. So you just get the detail, and it's up front. But clearly, guidance and will help with that as well.
So
Ms. Brennan wanted a quick comment on that. Sorry.
Just in relation to obviously the guidance and the other relevancy and the relevancy tests, only the checks that actually are coming through a level 2, which are then triggered to Police Scotland, would then be assessed for the relevancy, as I understand it. We are already working with the Home Office Quality Assurance Framework, and what we're hoping with the bill is that we will then have a Scottish set of guidelines, probably based on what is already in existence, because that was what was changed from the 2015 Sunita Mason recommendations, where it went from the thinks might be relevant to ought to be relevant, or should be relevant and ought to be disclosed. So I think those guidelines, if we can then have them within the bill, we then would have an assurance perhaps for those who are concerned about the relevancy tests that are undertaken, and it would be something that would be pertinent to our own piece of legislation and relevant to our own information that's retained.
So at the moment, it's difficult for an individual to know precisely what will be disclosed because of the absence of detail in terms of those tests. I wonder if the flip side of that coin is also from the public's perspective, as it stands with the bill, the public will be very reliant on Disclosure Scotland interpreting what the requirements and responsibilities of roles are that are being applied for through this scheme. And I'm just wondering whether there are any concerns about that in terms of the ability of Disclosure Scotland, or whatever body it would happen to be, to fully understand those things and get it right. Is there a danger, for example, of them misunderstanding and therefore not disclosing information that would be relevant, which should be disclosed?
That when a request is triggered to Police Scotland to assess that other information that may be held, whether it be a pending case or whether it be intelligence information, and it is only certain requests that actually come to ourselves for assessment, when we then apply those tests, they are based on that Home Office Quality Assurance Framework, which is available to anyone who wants to look it up. We obviously have used the basis of that as our principles to undertake those tests. When we then send those requests back to Disclosure Scotland, as I understand it, I don't know that they make any changes to our information, because that's the Chief Constable has decided that that is the other relevant information that we want to share with Disclosure Scotland. Obviously, I don't want to sort of move on to the next steps because that would then be the dispute process and the representations. But the independent reviewer, which is a new post, which has actually come from the age of criminal responsibility, but is obviously a much greater role within the disclosure bill. That obviously gives a better ECHR, human rights opportunity for an individual to see that information before it is then shared with an employer.
Mr. Gay, quick summary.
So most of that evidence, or all of that evidence really, has been around the principles and the tests regarding ORI, and I appreciate that the guidance for the new scheme isn't there yet, but there is guidance at the moment, the Home Office guidance, which Police Scotland work to. I'm quite interested in the actual practicalities of how this works. I mean, the decision is taken by the Chief Constable, but I'm guessing some other people are involved too. And so I'd be quite interested to know how the police actually handle that and where the Chief Constable comes in. And
so we would regard ourselves as delegated signatories in respect of the legislation for the Chief Constable. As you imagine, we're the ones who actually undertake the tests. So when the request comes in, we would then assess all of the relevant information which is pertinent to that application, whether it be a pending case information or whether it be intelligence information, and then we would assess it as against the relevancy test, so accuracy, relevancy, proportionality, and with obviously very much in our foremost is the ECHR elements of it. So it's that balancing the rights of the applicant against the rights of the child or the vulnerable adult.
you mean
My team.
Your team?
Yes.
So that's the disclosure team in Police Scotland?
Yes.
How big is that then?
We've actually across the country probably got about 72 people, maybe about 60% of them are working on PVG.
So you said that you were delegated signatories?
Yes.
Does that mean the Chief Constable doesn't see this decision at all then?
Very rarely.
Okay, thanks.
Okay, thanks. Ms Harris?
Good morning. I would really like to ask you about the cost implications. And I noticed that, you know, Nicola, you said that as cause they're concerned, there's not really, there would be a minor cost implication. But could we explore that a bit further? Because if the bill passes and the renewal system comes into place, then you're going to have a current cohort of all PVG people or members who are all at once going to need into the new scheme, which is an initial cost. But my question is, have you thought about it? You know, 5 years down the line, there's obviously a liability that will be created for organisations. I think it is actually quite a large liability sitting there that they're going to have to budget for and, you know, plan for financially going forward. But it also have an implication for third sector groups. You know, I know you mentioned Scouts, etc. So have you given that any kind of thought? I would first like to ask you about that.
So I think that's why I said COSLA recognises that the financial memorandum estimates that the costs will be minimal. I think there's never an exact science to a financial memorandum on the face of a bill, at least not when it's introduced at stage one. It's not necessarily what it looks like when it's introduced. I think from a local government perspective, we recognise we will get into a situation where it swings and roundabouts. So we may well, you know, have an upfront cost and we will then move forward. But I think we are interested in doing some more of that modelling work. Over and above the financial issues, we also have the resource implications. So my team are also responsible for the early learning and childcare expansion, which I'm sure you all recognise is a significant undertaking and we require a significant amount of workforce. So I suppose we need to factor that in at the same time. So there'll be the resource implication financially, but there'll also be the personnel implication for doing that. And that's not limited to local authorities, as you know, because we have third sector and private providers who are also upscaling their workforce to meet the expansion programme. So I think from a local government perspective, we are interested in working with the government to get the financial modelling as spot on as we possibly can. But I have to say, in balance, there has not been any pushback from the government in doing so. So I think on the previous point around guidance as well, the way in which the bill has been approached to date has been very much in a collaborative fashion. So I'm not here suggesting that we won't do that work.
So coming on from that, has the panel given any consideration to maybe, you know, the transition to the new scheme? Maybe it could be any thoughts on staggering it, or because, you know, I personally think there will be a financial implication. So, you know, I think that is quite important that we can look at that.
We've been doing a bit of work with Disclosure Scotland on that, just very initial discussions. One of the things that I would say in relation to the cost is that certainly in the social service sector, disclosures are repeated every 3 years, so that's one of the things that's having to happen at the moment. So people that are members of the scheme, it's not a lifetime, well, it is a lifetime membership, but they're having to get these updated, so there is a cost for that every 3 years. So perhaps the 5-year membership could bring some savings, but offset against some costs. I don't have any of those details for you. In relation to the implementation, I think there's got to be a lot of thought around that. You know, whether everyone is moved on to the scheme initially and then a staggered renewal period. So, you know, people that have recently paid to become members of the scheme, then they're later to be renewed and that kind of thing. That's the sort of discussions. But like I say, it's very early discussions that we're having with them.
Being discussed, so yeah, that's good. Thank you.
Andrew, Mr. Alexander, yes.
I mean, we hadn't looked directly at the kind of financial implications because organisationally, you know, sort of with 587 solicitors admitted in the last year, it doesn't affect us. But one of the areas that we did think was important, and echoing kind of comments earlier, was around the idea of publicity, because what had struck us was that with the huge number, you know, we're into 7 figures worth of people who are involved in the PVG scheme, and also the fact that there is a criminal sanction ultimately, you know, sort of if people were to continue to do, you know, sort of this work beyond the kind of termination of their membership, and also a criminal sanction on the organisation that allows that to occur. That I mean, and that is the right approach. But I think a degree of information being, you know, sort of available across the huge numbers of sectors that are involved in this, to make sure that there is no one who inadvertently kind of falls into that challenge. And it was something that had struck me from the previous evidence, talking about how communications had been sent out to people to tell them that they no longer needed to be part of the scheme because they were no longer carrying out this work, but the feedback on that had been apparently mixed. So I think that some resource to make sure that everyone is aware that this is going to change because it will affect such a large number of people would be helpful.
Okay, thank you.
Okay, Ms Smith.
I've got some further questions about the costs. Ms Brennan, can I just clarify something before I ask the first one? In an answer to Mr Gray, you said that you had approximately about 72 people around Scotland working on this. And did I hear you correctly? It was either 60 or 60% of them were full-time on disclosure?
Yes, so in my information management disclosure team across the board, so I've also got responsibility for data protection, subject access and freedom of information. So it's 60% of my 72 are probably working on PVG.
Right, thank you. Do you foresee that this bill would cause you to increase that number?
What we've suggested to Disclosure Scotland, the concerns that we have in relation to the staffing are more in relation to our responsibilities for processing the representations element of it. So if we then are putting out other relevant information, it would then have to go to the independent reviewer first. So at that point, if we then have something like that, we would then have to undertake another clean review, not by individuals who've already worked on the first disclosure. So that's where our concern is that we might have to then have more staff to support the representations element. What I would say in relation to the other part about the sort of financial and the numbers on the scheme, we've currently, I think, got 1.2 million people on the scheme. There's not 1.2 million people working within regulated work in Scotland. So there's a lot of people on the scheme who, because they are scheme members, are then subject to ongoing monitoring. So I think we could have a positive impact staffing-wise, in relation to the ongoing monitoring, where we'll then have the additional responsibilities is actually in relation to the applications. So many years ago, when we first had applications, we had a lot of applications being assessed and very little ongoing monitoring. Over the years, we've now got fewer applications, a lot of ongoing monitoring, so it will go the other way again. So we'll have more applications and less ongoing monitoring. So it should be, I would hope it would be evened out. But what we've said to Disclosure Scotland, it's the independent reviewer responsibilities.
I'm very interested in that response. I do understand why it might be balanced out. Having said that, though, if it's moving towards a mandatory scheme, there will obviously be more people who will become mandatory on the list. And that in itself, am I right, would create some kind of cost, not just to them individually, but to the monitoring of that?
Well, I think, again, it's when you've then got a core, rather than the 1.2 million, we would end up with whatever number of core individuals who are then actually working within regulated work. And the beauty of the new scheme is that we're then not dealing with schemes, you know, child or adult. We would then be actually in regulated roles and responsibilities. So in actual fact, from our point of view, we are looking forward to that, because it then means that when we're assessing the information, we're actually looking specifically at the role and responsibility an individual would take, as opposed to a more generic consideration of, well, it's within the scheme, they might be driving or they might not be driving. It will be more honed in, I think, on what we're actually looking at. So I think it might be easier.
I just ask about, I was interested in what you said about 1.2 million people being on the scheme but not necessarily involved in jobs that require disclosure. There are obviously people who have been on the 3-year disclosure system, but I know of some who've never been asked to update them, or never been told by the group that they're working with to update. Whereas this bill, I would suggest, would make it clearer that there is an obligation to inform them that they must be. Again, could I ask, that there must be some extra costs involved in that? Well,
I think if you look at, you know, the sort of good examples that some organisations are doing to proactively have that turnaround of a 3-year. Some, you know, if we then have a mandatory, it's 5 years, and then that responsibility is there. You're quite right, there are certainly individuals and organisations out there, because it's not a mandatory scheme, there is that potential risk of individuals working in regulated work who have never been through the disclosure process, which is a huge risk. At the moment, with what we've got, and we don't know the actual detail of how the turnaround will be, and I know there was a lot of work done for the retrospective checking when the PVG first came in. So at the moment, we are assuming or hoping, until we actually see the detail, that the sort of balance of applications against their ongoing monitoring will improve over time. We have a good relationship with Disclosure Scotland, and we have yearly budget discussions. So I would hope that once we actually see the detail of what we've got, and certainly the discussions that we've had in relation to the independent reviewer and the numbers that we think that might be involved, is very much from that discussion with Disclosure Scotland and ourselves.
Now, I think, you know, everybody's relatively positive about the general principles of this bill. I don't think there's any disagreement anywhere about that, and that's very good. But when you drill down on some of the detail, I think there are some hidden costs in this, and I think we have to be very clear about what these costs are, and whether there might be any detrimental impact on, you know, clubs or you know, societies who don't actually have very much money. First, they've got the obligation to ensure that the people who are working with them are properly told about, you know, the responsibilities they have. But if they are associations or clubs that actually take responsibility for paying the £59, that we're not stopping that happening, because that's something I would worry about, not least because of the pressure that a lot of the voluntary organisations are under. Yes. Is that something that would concern you?
Certainly from Police Scotland, it's not something that we are actually involved in, but certainly we had that conversation earlier just to say that yes, there is definitely a concern that how does this impact on organisations, how do they do, and what you would not want to see is that because of a cost implication that somebody then avoids doing something which is mandatory. And that is something which Police Scotland within the new bill would become a referral agency. So if we then identified that somebody was working within regulated work and was not a scheme member, then we would have that opportunity to then refer, which is something which is new within the bill, and again we welcome that.
Sorry, can I just get a bit of clarity on that? What would happen in that instance?
So if somebody is working within regulated work when it becomes a mandatory scheme and they have then not got the relevant certificate, if we then identify that that is an offence, well, we think that would be an offence within the Act, and Police Scotland would then have an opportunity to then refer to Disclosure Scotland, as would many organisations already have that referral opportunity. It's just not something we have at the moment.
Okay, thank you. Thank you very much.
Thank you. Ms Wishart.
Morning, panel. I'm interested in the definition of protected adult. And part of the three-stage test is to determine when an individual is undertaking a regulated role that the activities include the opportunity to have contact with protected adults or children. One of the respondents was concerned that this definition focus on adults, I quote, by reason of physical or mental disability, illness or old age, require support or who are receiving health care. And the concern there was that victims of domestic abuse may not meet the criteria. So what does the panel think on the definition of protected adult? Is it sufficient?
I certainly think that it was an area that that when we were looking at the bill, members of our Mental Health and Disability Committee had raised that the definition of protected adult under Section 76 was somewhat kind of different from legislation, stuff around vulnerable people elsewhere. And I think we'd specifically highlighted that an individual could qualify for personal independence payment or disability assistance, as it will be in future, and need a carer to meet assessed needs, but still not be considered a protected adult for the purposes of legislation. So I think that was one area where we thought that additional consideration could be made. And I think we were also aware of the response from Scottish Women's Aid, which had highlighted this as a particular area. So we did think that potentially going back to look at this definition again would be a helpful step.
Thank you.
Does anyone else want to come in on that? Yeah, thanks.
COSLA are co-signatories to the Equally Safe schedule, so I think that if Scottish Women's Aid have raised it, it's certainly worth something for us to be looking at that, because I don't think we want to be jeopardising any of the good work that we're doing around about Equally Safe through an unintended consequence. So from a local government perspective, we would certainly be happy to work with the government and Disclosure Scotland to look at it.
Okay, thank you.
Can we move on? Mr Gray, did you want to come back in?
Sure. I wanted to go back to, we talked a bit about convictions under 16, and I wanted to ask a little bit more about the age at which convictions should cease to be treated as childhood convictions, because Clan Childlaw's submission has a very different, expresses a very different view, I think, from other submissions. I think you suggest, Alison, that the system should pertain till the age of 25, and I just wondered if you would say a little bit more about why you make that, why you believe that to be the case.
Yes. Excuse me. Yes, we put that in the response, really having looked at the research provided by the Centre of Youth and Criminal Justice, and their research by Donna McEwen suggested that was the appropriate age, that young people are still developing up to that age. So apart from that, I don't. That's where it's come from, and maybe you can ask them more about that. In my what I'm saying today is that based on the UNCRC, 18 is the age that is protected by the UNCRC, and the principles for looking at childhood behaviour, that would be the cut-off in law that's required.
Oh, confused then as to which age you're suggesting is the appropriate one.
So in terms of the research, there is clearly development of young people up to the age of 25, And so that's why I put it in the submission, because that was what the research said. I don't know anything more than that about the research. In terms of the UNCRC, then 18 would be the appropriate age.
So I don't know if any other members of the panel have a view on the idea of 25 as an age for...
I think we'd obviously seen that as a piece of evidence, and the suggestion that there are neurological developments that take place into the mid-20s. We sit with the UNCRC as something that we're consulting on incorporating into domestic law, and that does, as Alison says, bring 18 as the period. We also have the age of criminal responsibility changed, and the potential for that to be reviewed in future. And so that could potentially be a vehicle at which stage evidence around the effect of offending in childhood stages could be reviewed again.
Okay. All right, thanks.
Could I ask a quick supplementary on that? Because also, obviously, the Children and Young People's Bill that was put through, we did put access to support services up to age 25 for looked after children. Do you see that there could be a special case to be made for looked after children in this instance?
I suppose from a COSLA perspective, we support in principle raising the age of criminal responsibility to 16. We recognise why we've landed where we have, but we're very much on a journey. So I think broadly, that's where COSLA and local governments sit. I do think we have to continue to develop the evidence and make sure that the bill, as we move forward in the context, does take that information into account. So I don't think we would be absolutely dismissive of that, but I just don't think that we've got the evidence nor the public perception perhaps at the moment. So again, I go back to that point about we have to make sure that we're doing the right thing in terms of balancing the rights and needs of our children and young people, which are paramount, but we also need to keep that public safety and public perception point. So I think we wouldn't dismiss it, but I just don't know that we're exactly there at the moment.
Ms Campbell?
Let's see, we don't have a fully formed position on a particular age of when offences should be disclosed. But and going back to Alison's point and Andrew's point, I think it's about providing the evidence to make that informed decision about, what that age should be. What we feel is that on occasion there will be times that the conviction of a child might have an impact on our decision of whether that person is safe to be working with some of the most vulnerable people in society.
Okay, thank you. Ms Mackay, did you want to come in?
Oh. Actually, it was a follow-up to Liz Smith's line of questioning. Can I?
That's fine.
Is that okay? Yeah. It was just on the point of. Well, good morning, first of all. It was just on the point of the line of questioning. I think Sheena Brennan, you said if someone was referred for not having disclosure and they were working. It was just a wee bit more detail on that. Who would, first of all, how are you expecting people to come to you to tell you that? Or how would you find that out? You don't proactively look for that?
It's if we identify, at the moment within the current legislation, there is no referral process for Police Scotland. If we then have the new bill and you then have a mandatory scheme and you're then working within, again, this is where we understand the bill, if you're working in regulated work and it's a mandatory scheme and you have not gone through the process, then effectively it is an offence to be working within that area of work with not having got the relevant disclosure. So if we then identify that, so say for instance, officers are investigating a crime of some other matter, then identify that an individual is working within regulated work, does not have the relevant disclosure, then the opportunity is then for us to refer that to Disclosure Scotland for them to take the decision and just to share that information on that basis.
So they would take the decision then whether that person was, I suppose, guilty of not having disclosure. And what would the sanction, what would the would outcome of that be?
We don't have any detail in the bill as it stands, as far as I understand it. But we did have a conversation earlier on about, you know, that some people, some organisations will obviously have individuals working with them who have not gone through the disclosure checks, and that is a gap in the legislation at the moment. But that would be resolved by the mandatory element of the scheme going forward.
Would the organisation be responsible or the individual?
Both, in actual fact. You know, there's at the moment we have certain offences which are auto-barred. So, you know, if you are convicted of whatever, it might be an auto-bar offence, so you're automatically barred from working with children or vulnerable adults dependent on, and that's something that Disclosure Scotland would process at the moment. But that's only for certain offences. Going forward with the bill, given the fact that it's a mandatory scheme, if you're then working within the regulated workforce, then you must have, and if we then identify, and if anybody, any organisation identifies that somebody is working in that area, it just means that the police now have a role within the new bill to then refer that to Disclosure Scotland.
Thank you. I mean, Nicola Dickey spoke of the need for public awareness and, you know, the campaign when this bill is enacted. And, you know, obviously I think, you know, some of the things do seem a bit vague, and the fact that, you know, what would the sanction be if you didn't have disclosure? You would need to be able to make that clear to the public. So obviously I think that's a gap that would need to be looked at.
Have to be proportionate. So going back to the point about how do we transition from where we are to where we need to be, again, I suppose the 1.2 million people who we know are currently on the current scheme don't all do the same type of things. So again, it would be in our gift to consider how we would actually do some of that, so that we were getting to the point where, before people were being sanctioned for not being part of the mandatory scheme, we'd actually had a conversation with them to say, just come off the existing scheme and you don't have to transition. But I think that's the level of detail that we would need to get into, so that the system is not in a state of flux at a time when it's going to be really, really important. As I say, going back to the early learning and childcare expansion on a personal level, that's one I really need to land particularly well. But we also have the kind of ongoing turnover potential of staff around about Brexit, so we don't know what the staff is going to be like. So it'd be really important that we transition this in a really helpful way, so that we don't have the system in a state of flux when we need it most.
Important point, actually, the Brexit factor. Really important point. Thank you.
Thank you. Mr Greer.
I'd like to return to Alison questions at the start around under 16s and moving the minimum age of the scheme to 16. And just to start off with, to clarify a point that I think Nicola Dickey made in that opening set of questions around under 16s. Am I right in saying that you said that there would be a responsibility if someone was under 16 but one of the granted very small number of people who are barred or restricted in their interactions with vulnerable groups, that the responsibility to disclose that still exists even if the individual is a minor?
That's my understanding, that we would have to we would have a public safety perspective on that, and we would disclose. But
there would be a responsibility for that individual, for the child, the 14 or 15-year-old.
So I think again in the policy memorandum, it would not be that we would be sidling up to a 14-year-old and suggesting that they disclose stuff without any support. I think in practice, the way that actually works is that, because under all of the existing policies and procedures that we have for our children and young people, these are ongoing relationships that we have with these children and young people and the people who have parental responsibility for them. So I think it's that conversation being had in a supportive and informed way. I don't think for a minute it would be a black or white, you know, you either sidle up to the voluntary organisation or you stop doing the work. It would be, this is what's in your best interests, and an awful lot of that would be as part of that ongoing protection and children and young people's outcomes. That's the way that conversation takes place on the front line at the moment, and I don't see that changing as we move forward, and the numbers are small.
Thank you. The main argument around moving the minimum age to 16 seems to be that for those under the age of 16 who would otherwise be part of the scheme, if they are restricted for whatever reason, other statutory services are going to be involved in their life. One concern that I have around that is when one of the young people in this position may move area in particular, that it would not be the first time where particularly move between local authorities would see, at least on a temporary basis, a break in the kind of responsibility from statutory services that we would want to see. I suppose that what I'm looking for here is some reassurance, or if you do share that concern, if you'd like to explain that if someone under the age of 16 would otherwise be barred or restricted if they had PVG membership, if this bill is passed, they will not be required PVG membership, but they are not in a situation where monitoring by a social worker, whatever it may be, is continuous due to a move, that there's a risk for, even if it's a limited period of time, there's a risk in that situation.
I would much prefer to concentrate our efforts in making sure that that person doesn't have a gap. So I think that would be a far more helpful way, not least because, not even just around about Disclosure Scotland, there are issues for children and young people if they are not transitioned between public services or local authority areas or whatever. So I think it is a small number, and I would much, much prefer that for the outcomes of those children and young people themselves, that we work with all of the professionals that we have to make sure that those transitions between authority areas or between public authorities are done in a way that, you know, so I wouldn't be using this bill to try and fix that problem. I think proportionately this bill has got it right. I think there's a separate conversation to have around about the way in which our children and young people move between local authorities. And again, I come back to the kind of GIRFEC approach on that sort of stuff. If you get GIRFEC right, none of that should be happening in an unplanned way. We shouldn't have young people who are, even for a very limited period of time, without the correct support. And the disclosure bill is only one part of that.
I mean, I agree absolutely that there's more work that needs to be done around transitions, but it's not that this bill would be used to solve that problem. As it stands at present, someone under the age of 16 can be a member of the scheme. This bill would change that. And given the situation at present is not perfect in relation to transitions, the scheme at present does resolve that issue, because an under 16 in doing this kind of regulated work would be a member. This bill changes that to a position where they would not be, in a world where we acknowledge transitions aren't perfect. That's the concern I've got, is we are creating a vulnerability here rather than trying to use this bill to resolve an issue that can be resolved elsewhere. It is already resolved under the current scheme.
That's certainly not the opinion of the professional associations that I've had conversations with. So I think from a COSLA perspective, we're pretty clear that the bill has it almost right. I don't know if that provides you enough assurance. Again, I think this is not being done in isolation. So again, as part of the work that we're doing around about youth justice, as part of the work that we're doing around about the Children's Hearing System Scotland, all of that stuff is going on, and it is the exact same conversation. It just so happens that we're talking about Disclosure Scotland here. We've had similar conversations around about, you know, youth justice. We've had similar conversations around about that.
Thanks. I suppose going back to the core issue with this, the question that I'm still looking at having a clear answer for is around what is the problem with having under 16s in PVG scheme membership? And the explanation certainly from the bill team is essentially that primarily this is about trying to strike a balance between risk management and the administrative burden of having a substantial number of people in the scheme who would overwhelmingly not be who would not pose a risk and who would not otherwise be restricted. And I understand that is a perfectly legitimate debate to have around striking that balance and creating, trying to create a system that's not overly cumbersome. But beyond that issue of administration, are there any other inherent issues with having 14 or 15-year-olds be members of the PVG scheme?
So I'm not sure that it would be proportionate against the risk that would be posed by these individuals. So I think this would be a whole, it would be all of the 14 and 15-year-olds would be in, as opposed to a very, very small minority who are currently actually applying for the PVG scheme at the moment. So again, from a UNCRC perspective, and I'm wholly aware that there are real experts on the law here on the panel with me and they can comment, but I suppose the balance for me around about putting all of our 14 and 15-year-olds in and having their behaviour being monitored at all times doesn't seem to fit against the wider conversations we're having around about children and children's rights across the country.
I suppose that's about balancing the risk between children. One child who is engaged in work that would be restricted if they were a few months older, and the children that they're then working with. So I suppose, Alison, I'd be interested in your perspective on that from Clan's point of view. Am I getting this right? Is this essentially about balancing the rights of the two different sets of children here, the ones performing the work and the ones they're performing it with.
That's my understanding. I have to say this is not an area that we've come across in practice, and we've not formed a settled view on it, so I'm not sure I can be of great help to you on this issue. But
I think just in relation to the sort of proportionality, you know, where we are probably talking about a handful of children who actually are individuals of concern, which would be, yes, absolutely. There is, as I said earlier on, you know, we've got a situation where organisations have the responsibility to ensure that their own safeguarding and protection roles, if they are taking on volunteers, maybe at 14, 15, you know, to ensure that they are not put in a position where they've got one-to-one access to children just in case. You know, it's about organisations taking responsibility again, and sometimes that's in relation to going back to the publicity and the awareness campaign that needs to be run for the new legislation, you know, to then say, you know, here's the situation. If you've then got people working within your organisation who are under 16, there are your own safeguarding responsibilities to ensure that these are in place, because they're not going to be subject to the Act, and that's what you'll need to do in the meantime. But as we say, I mean, we are talking probably about 6 or 7 children that we are aware of that would be of concern.
Thank you.
Thank you. I move to Mr. Patterson.
Good morning. I'm going to ask a couple of questions on regards to the list. So can I ask whether the panel agrees with the continuation of the system of having 2 lists?
I think I've made my position clear in that, in relation to children, and that I don't think that we should be getting involved in lists at all, and that the scheme shouldn't involve convictions for under 18s, especially those in the children's hearing system, and that there is a route to further information through the other relevant information with a kind of high bar set on that other relevant information. So in terms of the lists, I'm not...
From a Police Scotland's point of view, we are not actually involved in what's on the list. It's a very much a Disclosure Scotland responsibility. So unfortunately, it's not an area for ourselves to comment on.
It was one which we had highlighted in our response. Obviously, there is the ability to change the lists over time, incorporating you know, sort of potentially new offences, or changing for reasons of policy the priority that's given to the various things, and also I understand by affirmative procedures, so giving, you know, sort of the opportunity for detailed scrutiny. I think one that we had highlighted, if we're looking at kind of the division between the two, being around kind of positions of issues of honesty or positions of trust, was, you know, we particularly highlighted embezzlement and fraud being separated out, because often those can be charged as kind of alternative offences under the same matters. And we'd also kind of included kind of other offences which we thought, you know, so potentially could be included on list A, including perjury, attempting to pervert, or attempting to defeat the ends of justice. So we had thought that those were areas that could merit kind of further consideration, and as it sits on the face of the bill, to make those changes if that was deemed appropriate.
To the lists itself, could the system function without a list, in your view?
I think that would be more challenging to operate on that basis. You would be bringing more information. Well, if you were to move everything from list B to list A, then you'd be bringing more information into the domain where it would be disclosed. And I think I'd certainly kind of, there would be concerns about shifting things the other way, where very serious offences were subject to less of a regime. I think one of the other things that we are conscious of is the fact that there's some degree of consistency between different jurisdictions across the UK would be an additional area. We're aware that some sort of respondents around this bill have suggested that potentially there should be differential lists depending upon whether the person is a young person or an adult. But sort of in terms of that, when we'd considered it, we thought that we would need to see a kind of evidential basis for making sort of the distinction between the different lists. So undoubtedly there would be different ways in which this could be approached, but I think that overall we were content with the A and B approach, but with some modifications as to the types of offences that sat on those, just to make sure that, so certainly for our purposes, where we're looking to safeguard the public and where solicitors are in situations where they have an important position of trust, helping people, with very significant issues, often at very distressed times of their lives, that there was that kind of robustness of approach that we were able to apply when we used the disclosure system.
And Cheryl Campbell.
Yeah, we would echo just what Andrew was saying. We certainly appreciate the rationale behind having the two lists, the lists A and list B. And also just one of the things that we would like to be assured of is that there's some sort of consultation around what continues to be on list A and or any review of list A and list B, so that we are content that that meets the needs that we are looking for as a regulator.
Okay, thanks for that. Anybody else? Okay. Another question, and I wonder if you could comment whether the timescales set out in the bill in relation to list A and B are appropriate.
Something that was raised from our professional advisors or in any of the conversations that we had at a local government perspective, that the timescales were wrong, so we're content with the timescales and the list.
Any other comment? Is that not a question that really should arise then? Okay, thanks very much. I think part of this question I'm going to ask has partly been answered, but I'll open it up again and see what everyone would want to say. So I would ask your opinion whether the provisions in relation to childhood offences, namely no time limit for review for list A offences and 5.5-year disclosure period for a list offence, actually suitably differentiates childhood offending.
So my view is that is an arbitrary distinction, and that feeds into the difficulties I have with this approach, particularly for children's hearings, where really it is about welfare. The whole system is set up to do what is best for the child, yet we're imposing into adulthood, we're difficulties with young people then moving on from that. And I suppose I just wanted to say one other thing about that. There is an element of other factors that come into the decision as to whether a young person ends up at a children's hearing faced with grounds which are offence grounds, which could then lead to a conviction. Because when the reporter is making that decision, they're looking at the whole circumstances of the child. They're looking at what's best. They're looking at what involvement the child already has with the system. And so it feels arbitrary as to whether actually an offence grounds ends up at a children's hearing, which then could potentially lead to a conviction. So I think that kind of feeds into the arbitrariness of that, of whether a conviction then it applies to the young person. So I think that again feeds into the thought that really it's a welfare-based system and that we shouldn't be having any convictions for young people in the children's hearing system.
Anybody else? Any other point?
With the position that Alison has just intimated there, again, I think it's about proportion, and I think it's about the fact that the system is in a state of transition. So as we consider where we may be in 2 or 3 years' time, around about the way that criminal responsibility applies to children and young people it will be very much a live conversation, I would expect. But again, in terms of complexity and in terms of if you have a specific list for children and young people, you are adding another layer of complexity, which is what we're trying to strip out to a degree. So again, the balances that have to be struck there about that kind of arbitrary nature and the rights of children and young people more generally is delicate, I would suggest.
Okay, thanks for that. And finally, do you have any suggestions for changes to the offences on the list A and B themselves? Is there any?
What Andrew was talking about, so we identified that fraud had been taken off list A and put onto list B, whilst embezzlement remains on list A. And for our perspective, these share the same sort of characteristics of dishonesty, and that is a real concern for us as a regulator who are assessing people's suitability to be working with vulnerable people.
We did identify, and we were pleased in relation to section 38 of the Criminal Justice and Licensing Scotland Act, which is about threatening and abusive behaviour, which has been moved from list A to list B. It's an offence that in childhood has been used lots in residential units, but for relatively minor offending behaviour. But in the adult world, it's really serious, and so we were pleased that had shifted. But clearly, that doesn't take away from my point that I don't want it anyway.
Okay, thanks very much.
Thank you. Could I ask some questions around the other relevant information? And obviously the appeal process and the independent reviewer is new to how this might go forward. But will there be greater transparency and certainty for an individual regarding whether non-conviction information will be shared as an ORI, and whether or how that could be achieved so that someone would have a degree of knowledge about what might be disclosed?
In relation to the current process, individuals have an opportunity to dispute the information to the Disclosure Scotland, and then the second dispute comes straight to Police Scotland, and then the third dispute goes for a court of law. In relation to the role of the independent reviewer, what will happen is that if we are determining that we want to push out other relevant information, that will go direct to the independent reviewer for assessment. So an individual will have the opportunity to have that assessment before it then goes to an employer. So I think from a transparency point of view, it is very much a positive for the applicant. The role of the independent reviewer is one where we've had discussions with Disclosure Scotland just in relation to their role and responsibilities. And given the fact that I would assume that it will mirror very much the role of the independent monitor, which is an individual who's been in place for England and Wales for a number of years. I'm comfortable that the role and responsibilities and that transparency route will be very much a positive. From our point of view, the key is obviously that Scottish Government guidance in relation to the quality assurance framework. And again, that would be something there that would be available to individuals to see the tests that are undertaken.
And just ask about the review process of ORI and how that works at the moment, and just if you could give us a little bit of an indication about how that might change with the new bill, really to see whether the balance of the review process should be included on the bill or left to guidance and regulations.
Well, I think the fact that the role of the independent reviewer is part of the bill, and obviously the related guidance. Guidance tends to be part of regulations as opposed to, because then you can obviously amend it. And I think there will be, it would give a better opportunity to then, as time goes on, if the role and the sort of relationship needs to be tweaked, so to speak, then that gives a better position if it's within the regulations. I think the review process itself, what we would want to do is have totally independent individuals who would be set aside only to review those cases. And one of the conversations we had with Disclosure Scotland was that there may be 150 of those requests a year, a sort of ballpark figure, just to say, right, okay, those are independent reviewer, they need to be done completely separately, no inference from anybody else who's been involved in the case before. And again, that's a transparency for the individual to then say, right, okay, this is a fresh pair of eyes, and we have a routing through our own team where, you know, perhaps a disclosure officer will take the first inquiry, and then it will be peer checked by a lead disclosure officer, you know, and so on up the chain effectively, so that there is, if there's any question, you know, and there's an assessment done at different stages. And again, that's to give a reassurance to the individuals whose information is being assessed at that time.
Okay, and just finally, in that whole process, when it comes to childhood convictions, are they treated differently? And indeed, is whether or not it's a looked after children that's been through the hearing system is treated differently too?
The information that we have to hand is very much assessed, and you know, that information is not just assessed against the paperwork that we have. You know, sometimes we'll go back to the reporting officer, assess the actual considerations of, you know, what was your understanding of how this circumstance had actually come to fruition, you know, what was the background between all of this. So it's a full root and branch assessment of all of the information that we have to hand. And I think that's the point where, when it comes to Police Scotland, it's not just convictions we're looking at, it's all of the documentation, and that can be wide-ranging and over a number of years. In relation to the age of criminal responsibility, obviously we've been involved in that, and the role of the IR comes in through that Act itself. We don't see a lot of work at that point within the ACR for the IR, because there are very few individuals where we've actually disclosed for under 12. But certainly when we move forward and we're then into the all of the ORI effectively, and the 12 to 17s would automatically go to the independent reviewer in the first instance. So that's quite clear. So all of the information that we would be assessing is with that due relevance, proportionality, accuracy, necessity, obviously taken into account with the ECHR.
Okay, Ms. Reid, did you want to comment?
Yes, I mean, I'm delighted to hear that, and that's all really good. What would be even better is if that I could have some certainty to tell the young people that that's happening, and that we can have something written down that I can give them some idea as to whether it will appear or not. Because at the moment, I can just say, oh, it probably won't, but I can't go any further than that.
And I think that's where we're very keen to have that Scottish quality assurance framework guidance, so that then there would be an assurance. And again, it's about, you know, even if the information even comes to us in the first place, because if it's of such a minor nature, or if there's no trigger that would actually bring it to Police Scotland, we may never even see it. So that's, again, a sort of reassurance. And certainly from the ACR point of view, we've had lots of discussions with the Bill team. We've actually got another meeting tomorrow, just in relation to how that information is even recorded on police systems. How do we actually get that information? Because clearly, at a certain point, it's not criminal information. So if there is factual information that requires to be shared, how do we then use that terminology? And it's to make sure that that balance, very much for the applicant and for the sector, is there.
And sorry,
No,
just, the other difficulty with this is that because of the relevancy test that is specific to the role, a young person doesn't know until they actually go for a course or employment as to whether anything will appear. Mm-hmm. And that's really hard then to advise on, because you just say, well, we don't know. So
and again, this is where I think the publicity in relation to whether a role actually is within the regulated work, whether you're then going to require a level 1 or level 2 disclosure. So again, that whole publicity of this is the new legislation, this is how it will be, this is where we're going for mandatory, this is where, you know, the whole sharing and marketing of that is important as well.
Okay, I think we've exhausted questions from the committee. Is there anything you wanted to say today that we haven't covered? Any issue in particular? No, can I thank you all very much for your attendance at committee this morning. We'll now suspend shortly and we'll be moving into private session. Thank you.